What's up, everybody? We're here hanging out at the Last Minute Live on vacation, still talking Brian Kohberger. It was a little over a year ago when I was on my post-Christmas vacation when the Kohberger stuff hit, and it really hasn't stopped ever since. And the hearing today, some interesting tidbits of it. We're not going to watch the whole hour long. I'm going to summarize and recap some of it for you. But there are a couple parts I want to play together so that we can listen to and kind of break down and react to reading between the lines about what is being said by these lawyers and kind of discuss that, answer your questions if you have any about what happened at the hearing. We'll get the tile and all that stuff updated later when John has time, but this is when I had time to jump on. I decided to just go live this time instead of record it and play it tomorrow, so we can just hang out for a little bit and I can answer some of your questions. But we're going to watch some parts of this hearing together. In the beginning, they basically make all the same arguments. And the defense attorneys say stuff like, well, Judge, you even said it was a good argument. You even said it was well thought out. So now we're asking for you to reconsider, but we're also asking for your permission to appeal it. And what that means is if they are going to go appeal this decision by the court, it's going to pause the case. It's going to delay the trial. There's no way that trial is happening now. And we know the state wants the trial to happen in summer of 2024. Defense wants the trial to happen in summer of 2025. We're going to hear some arguments about that. We're going to hear the judge's decision on that. But I did think there were some interesting parts early on, and especially I wanted to hear the judge's ruling and reasoning for his ruling. And the defense made some interesting arguments about how this case could last 28 years and could last forever, and how the state wants to kill the defendant. And the state took exception to that. So we're going to listen to some of those arguments now. If you have questions, let me know. I'm going to be looking through and starring as much as I can. I'm on my own tonight. John is out doing something, hopefully enjoying himself. I know it's like later, much later at home. We're going to dinner in like 2 hours. So I'm going to be up late tonight, on my time at least, because we're over in California. So the time's a little different. But we're going to jump in. We're going to watch some of this hearing together. So hit that like button. If you guys haven't subscribed yet, take a second, subscribe to the channel. All right. By the way, I also want to know what you guys think of the court's camera and mic setup. I kind of like it. I think it works well. I think that this is going to be okay, and we're going to be able to get plenty from it. There's not going to be any zooming in on Kohberger or anything like that. But my guess is during the trial, one of these boxes is going to have the witness. So we're going to be able to say the lawyer's in one, the judge in one, the witness in one, and then I don't know who's going to be in the fourth box if there is one. So I don't mind the setup of the cameras and how the media is being put out there. You guys let me know what you think. All right, here we go.
Mr. Nye, Joe Austin, reply.
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So
we don't want this to just be put away and forgotten. One thing he said. Number two, the trial is only part of this case. So it's interesting, and I agree it's the biggest and potentially most important part of the case. But he says if they get a conviction, this case is going to go on for 28 years. And he means all the appeals, mandatory and otherwise, death penalty issues, sentencing issues, things that happen in the first phase of the case, second phase of the case. This issue is going to be an appellate issue. And we've got so much going on here that this case is going to last forever, whether we like it or not, which I thought that was very interesting. Miraculous Hufflepuff said, why would the trial only be part of the case? The trial is only part of every case, obviously. The pre-trial phase, the discovery phase, which we're in right now with this case, is obviously part of it, and the trial is only part of it, but it's the culmination. And it's so difficult to go and win an appeal after you have been convicted. Leisha said they're talking too fast. You can slow it down to 0.75 speed, 0.5 speed. If you hit the little gearbox on my video, it'll slow it down and it should sound perfectly normal. We're going to get through as much of this as we can. I've got a couple clips I want to show.
the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking
a little threat there. You want to know how long this is going to take? Get some stuff wrong and then see how long it's going to take. Meaning, we're going to appeal you to death. We're going to file motions for reconsideration to death. We're going to make sure everything takes long. I mean, listen, nobody wants to do it twice. We talk about that from the jump. Nobody wants appeals. Nobody wants convictions overturned. Nobody wants to do this stuff twice. But that doesn't mean you just pause the case every time the defense wants to appeal something and you let the case take forever because it's going to take forever anyways. Everybody wants to do it right. It's incredibly important, not just for the defense, but for the prosecution. We talked about that with the rights of the media and the rights of everybody else.
That the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in the case where the state's decided that it wants to try to kill someone. Thank you.
Excuse me. Well, first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while.
This is basically the judge saying, I did say it was a good argument. I did say it was a novel argument, but it really wasn't that good of an argument. Okay. I don't think we got that wrong. I don't think anybody's going to argue with the standard of proof in a grand jury indictment. So he ends up saying no, but he's going to give his reasoning here. Kelly, thank you for gifting a membership. And Joanne asked, why does the appeals process take up to 28 years? It doesn't. I mean, it's different in every case, right? Sometimes there's trials that take 28 years to go to trial. That's a little extreme, but it does happen. And cases can take a really long time on appeal, or they could take a couple years on appeal. It usually isn't a delay. And appeal's coming no matter what in this case if there's a conviction. They're going to appeal. Even if everything was done right in this pretrial phase, they're still going to appeal. But I think it's kind of just like him showing how horrible this is all going to be, and it's going to take forever, and the trial's just part of it, which people say in literally every case because that's part of the process, that there's going to be appeals, and that does cause extreme delays usually. But there's a little bit of hyperbole there.
A while ago, it's rooted in well-settled law, and I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that
I agree, Judge. I think that was a correct decision because, like, everybody agrees with you across the world and for all time.
That it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of you. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but
it's basically like, I'm not worried that this is one I got wrong. If I was worried that maybe I could have got this one wrong, then maybe I'll let you appeal it. This ain't one of those.
That's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. This also has a second component. This is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year.
There's no doubt that this would cause additional and considerable delay. YYZ, newer to this trial, is he facing the death penalty? Yes, he is. Just Amber said, would there be a new judge if there was a change of venue? Not necessarily. They changed the venue and other judges have stayed on. Sometimes they do, but I would say probably not in this case. Dang it, I starred the wrong one. Somebody said, I do not see eye to eye with Judge on this one. What do you mean? Do you guys agree with Judge here or not? And also, Rebecca said, if you guys hit that like button, new members will appear. And she's right. We've hit the like button. Azam has gifted a membership. Thank you, Azam. And Rebecca has gifted 10 new memberships.
Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, I'm going to deny the permissive nature. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just refile it, as Mr. Knight said. So that's
correct. So even if the defense goes and wins this, the state could refile it, redo it, and then likely win, even with the higher standard, if that is the case. So we're just wasting time for nothing, basically, the court's saying, which also indicates that if it were to go on appeal, would they really overturn it on something that was likely to not really make a difference for the defendant? Now, it's not a good argument because we need to do things right. Justice needs to be done right. Due process needs to be done right. But this is not one of those arguments that's going to be winning anyways. And even if it did win, it wouldn't change anything, is what the judge is saying. Now, I don't necessarily agree with that with most arguments, but with this one, it's just not going to win. This is not a good argument by the defense.
That's significantly more delay. So there's some other, actually, this is in a case law, Buttle versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood of possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is.
That doesn't mean they can't appeal it later, right? If there's a conviction after conviction, they can appeal it. But he's not going to give them permission to pause the case basically right now, cause a delay, and appeal it now. No surprise. I agree with the decision personally. If you disagree, let me know why.
Substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, but obviously denying the motion to reconsider. And with that, I think we are ready to go to anything.
So then they go into scheduling.
Yes, I'd be happy to. And to start, Mr. Logden said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this,
My opinion, you didn't need to do this. Just let that one roll off your back and just don't get in the mud if you think they're just making arguments that don't matter and are just trying to just scream hyperbole for the media to report on. But he decided to answer it anyways.
with facts like this, A jury is entitled to decide not only guilt, but potential. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone, it's just simply appealing to raw emotion, and it has no place in this court. We would ask that that not be.
Yeah, but like to whose raw emotion? The judge's raw emotion? Like, who cares? Again, I did not think this was necessary personally.
Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, but she has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at this time right now, we believe that we could be prepared for trial summer of this year. We realize the defense has factors and considerations they want Your Honor to take into account, and certainly we want to afford them that opportunity.
So that's basically the state's argument, and we read these motions together about how the state wants to have it summer of 2024 because hotel rooms and University of Idaho is out, and that just makes the most sense. Defense said, no way, we don't think we're going to be able to do it. And we kind of talked, and we thought, when we talked about this before, if you want to go back and watch the video, summer makes sense. I do agree with the state's arguments on the summer, but there ain't no way it's happening summer of 2024. The DNA evidence is just happening now. Got to get more experts, more depots, 51 terabytes of evidence, maybe summer of 2025. And guess what? Summer of 2025 is what the defense asks for. And she said she's scared to even say that because she doesn't know if she's going to be ready. And I think that that makes the most sense. As horrible as it sounds, as huge of a delay as it sounds to a normal everyday person for a case like this, death penalty case, 2-phase trial with this many issues, with this much discovery, summer of 2025 would not be a horrible amount of time for this case to take. I think that would be 2.5 years, basically. That's not an abnormal amount of time. I think that would be a pretty fair amount of time. Now, will they continue to try to delay? I do think it's a little bit strange that they wanted to pause the case to appeal just that issue about the grand jury indictment, which they're going to lose. Number one, my opinion. Number two, now they're not even sure they'll be ready summer of 2025. Is the defense starting to want to delay and delay and delay? I would say no. I think based on some of the arguments, and we're going to hear some of the clips today, they really think they have some good evidence or holes in the evidence that are going to work in this case that are going to make a jury raise an eyebrow. The friends I'm here with have not been following the trial as much. And when I told them a little bit about it, they're like, well, wasn't he like stalking the girls for a while before? I'm like, I don't really know if there's evidence of that. Well, wasn't he following, DMing them on Instagram a bunch before? I was like, I don't really think there's any evidence of that either. We'll see. There were some comments and media reports, but I don't know if that's what the evidence is going to show. We got to wait to see what the trial says. They go, wait. So he wasn't stalking them. He didn't go to the school. He wasn't DMing them. He didn't date any of them in the past. So what's the big connection between him and the victims? And that's going to be some of the really important things that come out in this trial. They don't have to prove motive, but sometimes it's difficult to win without it. And, you know, we'll be watching for that and see exactly how the prosecution can put this case together. They talk about how there's 400 witnesses. The defense gets up and says, no way we can do this trial. 400 witnesses, we only talk to 10% of them. 51 terabytes is 6.5 million documents, 13 filing cabinets worth. They agree with a bunch of what the state says, but they just think because of how complex and how much discovery there is, and this is a death penalty case, a 2-phase trial, the media is making it hard for them to talk to witnesses. People don't want to talk to them because of the issues in the case and because the media is making this difficult. And, you know, a lot of people hate Kohberger, so if you're going to do something good for the defense, people might not want to be involved because of the media and the reporting and all of that. And that's bad. And we don't want that. We want a fair trial. We want people to feel like they can testify to whatever they saw and whatever they know, because that's really the point. And Jenny said 400 witnesses. So it doesn't necessarily mean 400 witnesses at trial. It could mean 400 potential witnesses or witnesses we need to talk about in discovery or witnesses we need to depose as the defense in the state. Could be that. Mrs. Jim, all of a sudden the prosecution's ready to go, yet they haven't handed over all discovery. they forced BK to waive speedy trial. I agree. The state's got everything they want, right? But guess who doesn't? The defense, which is why usually when they ask for a continuance, they should get it because they need to be prepared. They need to be ready. They need everything they need. Period. And that's what we said about the DNA stuff. And guess what? They were right, at least partially, about what they should get. Pharaoh said, when will this go to trial? I think summer of 2025 is when the court's going to set it. I don't think he made the decision today, but we're going to watch the rest of this. Rebecca, well then, the defense needs to get on it. Not fair to the victims. And that's exactly one of the arguments the state made. The victims have a right for this case to go, and they're correct. They do have a right. But if the defense continues to win motions to compel where the state's not turning over discovery that they're asking for, and then the judge agrees with them, and the state has to turn over some or all of the evidence they're asking for, I mean, you can't punish the defense for that. You really can't. And they have to have the opportunity to hire their experts and move the case. And again, nobody's going to want to hear it. But coming from somebody, again, like I just told you, I'm afraid and I'm ticked that this case I'm supposed to go to trial on in 3 weeks is going to get continued. And the case is almost 4 years old. And it's been continued 6 times. And we're doing everything we can to get it to go. And it's so annoying. I don't even think that the defense was trying to delay for a while, I think. I don't even think they're trying to delay now, but it's just the justice system gets so clogged up. So to me, 2.5 years is not unreasonable for a case that's this complex with this much discovery. All right. So let's jump in now to the next clip that we want to watch.
But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Brian Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over, picture considering a scheduling deadline.
So let me just introduce this clip before we get to it. This is the major hole in the evidence that the defense is bringing up now, saying, I've read this probable cause affidavit over and over again. They have 51 terabytes of discovery that they've had for months now, most of it. And she's gone through all that. So she's telling us something without telling us. And there's no evidence of a connection. How did they get to Brian Kohberger? How did they find him? How did they lock in on him? And that's something that they're definitely going to fight. And so let's hear her discuss exactly what they think is missing in this case.
Line for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Brian Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Brian Kohberger. I know different pieces, but I don't know where they fit together.
If I'm the state, and that's true, now maybe she's just blowing smoke, who knows? But if I'm the state and that's true, and she can't figure it out, my guess is a good defense attorney is going to be able to convince a jury. How are we sure? How did they get here? I can't even figure it out. How are you going to figure it out? How did they figure it out? That's not good for the state. No matter how you cut it, that is just not good for the state.
And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to...
She's like, we need those answers. They've got to tell us those answers. We need a deadline as to when they have to turn over those answers. And if you look at the judge, he's making notes.
Allow windows to file additional motions based on later disclosed materials too.
Sorry, let me pause it again here. I'll just tell you from my perspective, that is unusual. Usually we know how they found our client, the criminal defendant, easily explainable, makes sense. Even if you think he didn't do it, whatever it may be. Paige Willow said his car on video. I think there's some holes there, Paige. Now, maybe the state can put it all together and figure it all out, but this is the interesting part of the case, is the connections, how we got here, how he got here, why he did it. Again, not necessarily the elements they have to prove, but usually very good arguments for reasonable doubt.
I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well.
It's kind of the state's fault. And in criminal cases, the state usually delays giving evidence or giving discovery. In civil cases, it's the defense that usually delays giving discovery. And then it makes it so problematic. I mean, I have cases where defense, civil defense attorneys are just turning stuff over until the day of trial, and it's so unfair. How can you prep? How can you get ready? How can you know what you have to respond with if they're not giving you everything? The state needs to turn all this stuff over. They've had it for over a year. They need to turn over everything that's relevant that the defense is asking for. If not, the court needs to rule on motions to compel discovery. Now, the defense keeps saying it's not the state's fault. And I think that might have a little bit to do with the FBI or maybe some other law enforcement agencies that the state has no control over, not turning certain things over. And the state is satisfied with what they have to prove their case, but the defense is like, well, wait, what about this, that, and the other that we think is important to our case or may hurt your case?
That covers it.
Okay, one more question. So
Sure.
I understand this. I mean, I'm aware of amount of disclosures already. But do we need a whole another year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
The judge is like, what can I do to move this so it doesn't take till summer of 2025? But the state has made all sorts of good arguments as to why the summer makes the most sense for this case in this trial. And I agree. The hotels, kids being gone, families not coming into town, the spectacle that it is. The defense is also going to try to change the venue. They said that. And we're going to hear a little bit from the state about why they don't think that would matter. But judge wants to move it faster. Maybe like a judge's compromise would be maybe over Christmas break or the winter time of 2024, early 2025, somewhere between summer of 24 and summer of 25, splitting the baby.
That's a tough question. If the state says you have everything, and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say...
So people for the mitigation phase or talk about Brian Kohberger's life and stuff like that, it may have nothing to do with this case, nothing to do with Idaho, but they're from back home and they're like, we don't want people to know we were friends with him or are friends with him or support him or would say anything nice about him. We don't want to be connected to that. And that's tough and that sucks for a guy that's presumed innocent at this point. Shy Gal said, so is she saying there's a specific protocol for at what point they get a DNA match that it wasn't followed? Could the DNA get thrown out? Is that possible? So we're going to wait until she files her motion to suppress to get the DNA thrown out. Is absolutely possible. Will it happen? I don't know. I want to wait till she's had an opportunity and her team to review the DNA stuff that they're getting now, hire experts, put it together, because I would expect a motion to suppress that DNA evidence, and it can be suppressed or thrown out. Will it? I don't know. We've got to read those motions before we can really have a good opinion on that. Rebecca said, okay, what's the excuse then that they're not turning over the stuff, that there's going to be a reason here? There should be, and they're going to say either it's not relevant or the FBI won't give it to us or whatever it may be. But the state or the defense has filed a bunch of motions to compel, meaning we want this. State said no. Judge, you got to make a call. Judge says turn over at least part of what they're asking for. So again, it's frustrating. It happens in every case. But the delayed DNA and this much DNA, what did I say, 6.5 million documents worth, is wild. Netwoman said, okay, Peter, you've been redeemed from doing your way too early members only by doing this Friday Night Live. Thank you for doing this, but enjoy your vacation. I am enjoying it very much. It's very relaxing. The time change is kind of cool because I get up before everybody, like 5 a.m. this time, and I get to work for a couple hours, get everything done, gives me peace of mind to just chill the rest of the day. This hearing was only an hour, so I, watched it on 2x speed, picked out the parts I thought were interesting, and now we get to hang out and watch it together.
everything's going to go according to plan. I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you. And the records you need will be given to you when you ask. And the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March of 2025. And that's me saying I'm going to spend every possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team.
She's like, best case scenario is March 2025. But if one thing goes wrong, if one witness won't talk to me, if one delay by the state, it ain't going to happen. And I don't even know if I can get it done by summer of 25.
But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you that.
This is priority for everybody, and I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back. We can only predict the future so much, and we have so much power. So I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right, most of all of which need to be looked at to see if they have any potential relevance to the case.
It doesn't seem like they're disagreeing, right, with how much work and how hard this is going to be.
As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic.
And again, sounds like an agreement. Summer of 25 seems like the best time. I'm very confident that's when the judge is going to make that determination.
About being sure that we can get our witnesses here. We'll have something to put them. And there won't be undue interruptions in the community that can cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And I don't think that's a changing thing, Judge. When this case has national.
What do you guys think? Because we've talked about this before, so you probably know what I think already. What do you think about changing venue? Do you think that would help at all? Do you think that would help at all? Changing venue. Thank you so much, Roro, for gifting 5 memberships.
If not international attention. This spring, I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case. It's not Moscow. It's not Latah County. It's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position. I
agree with him. I'm sorry, but I agree with him. Do you guys? I'm not sure a change of venue is going to help the media attention here.
On venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to see a jury here first. And not just rely on there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court clerk down there, and they happened to mention co-rotation and said, what are you talking about? So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging. But I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Latah County.
Yeah, thank you, Mr. Thompson. So you're saying, looking at this realistically and the amount of information, evidence, non-evidence, that you might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty, and that's painful. It's an everyday reminder, and they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal. It doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah.
Some interesting questions popping through here. Catherine asked if Kohberger waived speedy trial. Yes, but only because he was forced to. Nancy Flint said, due to personal relationships in such a small area, I disagree with you and think they should change venue. It's a great point. Except that this is not the standard to change venue. The reason they're talking about changing venues is because they say they cannot get a fair and unbiased jury who hasn't already made up their mind about the case due to the media attention, basically. And the argument against it is, where are they going to go that people haven't heard about this? You can't go to Alaska. He was talking about some small county maybe they could go to where there's no lodging, which makes the logistics of having a trial like this a nightmare. But it's not about it being a small town and people knowing each other and stuff like that. But a lot of people do think that, so it makes sense. Paula said, how is it the state's problem that people don't want to talk to defense? That's not the state's problem. That's not. The only thing that would be the state's problem is turning over discovery that they have and they're not going to turn over. But it is the judge's problem because he wants this to be a fair trial and the defense be able to do the discovery they need to do. So if they say we need more time to talk to these witnesses because it's difficult, then you give them more time. If they say it's impossible because the witnesses don't talk to them, you can't force them to really. And they're not going to be helpful if they don't want to talk to you, and they might just come in and say something bad for your client. John said, put this fee towards a couple massages for Whitney and yourself. We're going to some nice steakhouse tonight. It's called Snatch or Scratch or something like that. So I'll put it towards that. And I am very much looking forward to this. Apparently they have some nice wine and stuff Whitney's looking forward to too, but I'm going to get myself a nice steak tonight if I can stay awake. It's 9:30 my time and only 6:30 this time. So might be hard. And John, I saw your other comment, and I'm just saving it to the end so we can have a little fun with it. I also see a bunch of comments about Crumbley, which we'll talk about that a little bit at the end as well. But I see a bunch of people asking about Crumbley.
I'm upset right now. I mean, I'd like to get
Catch. I was way off. That was like a Dumb and Dumber moment, Samson, Swanson. Oh, Samsonite. It's right here on the bag. And yes, I realize Snatch and Scratch. Pause. Pause, Peter. Pause. That's on me. That's on me. Hand up. That's on me. I'm the problem. It's me.
With discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe March 2025. Which that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want to direct a certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality. And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. Going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything to do it correctly, maybe we only have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times.
So the judge is basically saying, I wish summer of 2025 was not what we were going to choose because that feels so far away. But that's what it seems like he's leaning towards. Bone Arrow said, but why was he forced? Wouldn't his lawyer have advised him on what to do? Not enough time to get ready for speedy trial. Yes, and that's the point. He's saying he wanted to go, he would have gone, but because the state wasn't giving him what they needed and everybody was delaying this stuff and the court wouldn't paused the case so that he could challenge the grand jury indictments more. He has no choice. If he goes to trial in the speedy trial time period, he's going to get screwed, and he's not going to have competent assistance of counsel, so he has to waive a speedy trial. Now, that's not usually good enough for an appellate issue unless the state willfully committed prosecutorial misconduct basically by withholding things and didn't make legitimate objections and arguments. So we'll see. But that's what he meant when he said he was forced to do it. Jazzy's mom said no notification. Probably my fault. I'm on vacation. I didn't set it ahead of time. John's not here. I just decided to go live instead of record something to play later. So I apologize, but I'm glad you're here now. Catch up. 2 times speed.
Because no matter what happens, okay, if he's convicted, it's going to be appeal. And
Everybody agrees with that, but who cares? Appeal. If he's not convicted, or if he's convicted, should not affect our decision making now. What we need to worry about now is getting a fair trial, due process, all the evidence turned over that needs to be, so both sides can make the best argument they can. So this trial is preserved. It's going to get appealed. It's going to get appealed no matter what. We can't control that. If he's convicted, it's going to get appealed. Thank you, Netwoman, for gifting 10 more memberships. Great membership, or great live to show up for. Good chance of getting a free membership.
that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward with your life without this hanging over your head. So I'm sorry. We'll see. All right. So I'm gonna contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently.
So he's going to pause. He's going to contemplate, which means he might not just jump into this summer of 2025. Maybe he'll set it for March of 2025. That's if I was the judge and I was trying to push this case. I might set it for March of 2025. Hope everything is perfect. Try to push everybody to fix everything or to finish everything. Set all the deadlines for March 2025 with in mind that I would allow a continuance to the summer of 2025, which is just a couple months after March. So build that in. That's probably what I would do. But I think in actuality, the soonest this case goes to trial is summer of 2025. Thank you, Catacomb Man, sending love. Pete, may the truth prevail. Yeah, whichever way that is. That's what we always want. And Carolyn, thank you for gifting a membership. Mandy said, if the defense thinks there are so many holes, wouldn't it be a great time to go to trial? Not if you think the other side has the answers that you're looking for and they're just not turning over certain things that are connecting these dots. And the first time you're going to see all the dots connected is in front of the jury. If they don't have this stuff, then yes, it could be good. And you could just hammer home at those holes. But if they have it and there's not turning over certain things, you need to know about that. So that's what I think the defense is saying there. And Rebecca just going off the top rope, 20 gifted memberships. Thank you, Rebecca. I think this is about the end of it here.
Really? And I want to do the right thing. Okay. So, does that conclude what we need to talk about today, Mr. Thompson?
Looks so much.
Okay, Ms. Taylor?
Yes, right.
Okay, well, thank you all. We are adjourned.
All right. So that was it for the hearing. And like I said, I think summer 2025 is probably the earliest it's going to happen. But if it were me, I would try to push them a little bit, set the discovery deadlines up, and make it happen. Shelly said, Peter, thank you so much for doing the live and taking away from your vacation. It's dedication and just loving what you do. You're great. How do I purchase Lawyer You Know items I want to represent in Port Orange? Is that what that says? LawyerYouKnow.com is where all the merch is. LawyerYouKnow.com. Check it out. Are you looking for something? No? Okay. John, whose shoe was it? Sports fans got to know. So, if you could tell, and there's a little hint in the color, it's Jazz colors. It's Rudy Gobert, which is his signature here. Rudy Gobert shoe. It's the biggest one I've ever seen. I mean, that thing is huge. Look at this. It's a big shoe, man. Pretty cool. And then Victor Wembanyama is the top jersey here, which is also pretty cool. So that's it, John. I did not see a single person guess that. Most people guessed Shaq, so I need to go back and see if anybody guessed Rudy Gobert. That woman said every live is great to be on. That's because you're on most of the lives, That woman, if I'm being honest. That's probably why most people think it's great, because so many free memberships from you and Rebecca and everybody else, and Love and Lady D here, gifting memberships. Tom said, Peter, I second John's thoughts. Robert's rules right. Here's my contribution, and can't believe I caught this live by sheer luck. Keep up the great work. Yeah, you have to be lucky because it was totally random when I went on, but thank you so much, Tom, for this and everybody else that came and hung out today during this live or tonight for you guys or for some of you on the East Coast. Don't forget to hit that like button, and let's take 2 minutes on Crumbley. So I've been catching some of it, and it's wild. It's very unusual to see a defense attorney speak and act this way in front of a jury. I don't love it. It does not feel professional to me. I thought her opening statement was okay. I thought her opening statement was better than the state's, frankly. I am going to do kind of a Crumbley recap whenever I get back next week, maybe Tuesday, Wednesday, something like that, to just see what I think from the evidence. But being that flustered, seeming that unorganized, making comments about killing as jokes, kind of yelling at the state, whining a little bit, like it feels a little whiny. I don't love it. I think the state's been kind of frustrating in certain parts too. To me, it does not seem like it's been a very professionally run trial by the lawyers so far. You heard from who? The defense is leaving us with so many shocking moments. Yeah, I'm not loving it fully, but I'll have to reserve some comments till I can watch more of it and we can break it down with some clips together. If you guys have any kind of shocking short clips you want to send me, then maybe I can compile them together and we can do a live next week breaking all of them down. Azam, thank you for gifting 5 more memberships. Yes, Nicole. I mean, that's not just a slip of the tongue. That's like, it better not happen again. You better not have that slip of a tongue again. Okay. That's all I got. I'm out of here. You guys are the best. I love you all. Hit that like button, subscribe, tell your friends, share all the YouTubey things. But I'm going back to it. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.